It's nice to see you. I don't think I know almost anyone here. My name is Omri Ben-Shahar. I will teach some of you if you're 1Ls contracts next term. It's my main area. I also teach trademark law and a variety of other private and commercial law courses and law and economics. A few years ago, I've become interested in the relationship between law and artificial intelligence, law and AI. But not so much in how most of the field has developed, which is how law should regulate AI. So AI is Google and everything else that's going on, and how our society is changing, and what the law should do to catch up with the risks that are created by robotic and artificial intelligence methods. I was actually interested in the other direction. How law could join the party. How law could become fueled by AI. And I was inspired. It was this like one afternoon where I said at a lecture that then a visitor from Harvard, now a colleague at Booth School, Sendil Mullainathan, lecture that he gave about how he and a bunch of other scholars trained an algorithm to make predictions related to the granting of bail in criminal proceedings. And that tournament that they did against real judges, the algorithm versus the judges, and how showing that the algorithm would release more people, would grant bail more. Those, despite the fact that they would release more people, there would be less reoffending and flight from trial. And far and away, more racial fairness, less discrimination and bias against black defendants. This kind of win-win-win in orders of magnitude that are unheard of in any kind of law reform, criminal law reform, just blew me away. I thought to myself, well, I'm no longer in the early days of my career, but if I were to retool and start thinking about things nowadays and recommend to people topics, this is what we should do. That's what I want to do. I want to think about how algorithms can improve the law. Now I had one problem. When I went to law school, I also studied economics. I got a PhD in economics, but at the time I wasn't trained to do machine learning. And I was kind of, lazy to go back and start to learn the tools. So I thought I'll do other things. I'll think about rather than the implementation, the ways Professor Mullainathan implemented it through an algorithm, think of additional things that can be done. And this is what I'm going to demonstrate today. It's a topic that Ariel Porat and Ariel is maybe kind of, started thinking about this ahead of me, and we kind of joined together. He used to be a permanent visitor here at the law school, and nowadays he's the president of Tel Aviv University. And kind of we tried to jumpstart a new field in which you think about how various areas of the law could be switched from uniform rules to personalized rules. This might seem like entire science fiction, and it is. I don't fully believe that we are ready or that this is good, but I wanted to kind of provide an account, a theoretical, conceptual account of what would it be like. So what is this personalized law? Well, it is two things. It combines individually tailored legal commands. So instead of one rule for all, you have to drive. If you drive on Lakeshore Drive, you all have to drive at 45 miles an hour. There is a sign that is uniform. Each should have a different speed limit based on their skill of driving and riskiness of driving. Not different, not uniform, but different at times of the day, different for day night. But at the very same moment, each one of us would have a different speed limit, communicated through our dashboard or whatever. And it is how it is derived. How would we create these individual rules in the same way that the big data economy operates. Bunch of data about us that is related to those goals that the law is trying to achieve, maybe safety in driving, in that example. Tailoring it based on our individual data, so algorithms would figure out what factors matter and then would screen people. I'll give a lot of examples to make this less abstract. So think about age of capacity. For example, the age in which you can purchase liquor. 21. Uniform rule. When the state of Oklahoma tried to create different rules for men and women, 18, 21, based on the differential risk that they pose for, the Supreme Court, struck it in Craig v. Bowen, very famous 14th Amendment case, as unfair. Talk about equal protection today and about personalized law. But I'm not talking about different rules for, men and women. I'm talking about different rules for different people. Every person has their own age of capacity based on how they score on that particular metric that determines the reason that we need to restrict people. Responsibility, maturity, abuse, recklessness, whatever it is. Look, insurance companies do it all the time. They charge each one of us different premiums for driving based on factors that are roughly in the same neighborhood as what I'm talking about. So someone might be allowed to drive to purchase alcohol at the age of 16. Why not? Sip good wine once in a while. A bunch of nerds sitting and playing video games why not drink beer? Other people who have sports car and take them for late night, peak hour crash drives, should not purchase it until the age of 28. When it begins, the charts show that things begin to kind of flatten the recklessness. So, and some people might have their score updated over time. Say, well, you can't yet buy alcohol because according to your safety score, you have to wait till the age of, or you're already allowed to buy it. We thought that you are responsible and you can mature and you can buy it at the age of 18, but that can be revoked. So this is a personalized scheme, an example to begin to give you a sense of what we're talking about here. So what are these, more examples for these individually tailored legal commands? The idea of different rules for different people based on internal differences, how the person differs, not the external environment, but what we know about them, about their past behaviors and various other things. So personalized standards of care. Tort law, and we'll talk about some more of this in more, uses a standard of care known as the reasonable person. What is more one size fits all than that concept of the reasonable person? But under personalized law, there will be the reasonable you and the reasonable you. Whatever for you is reasonable, and you differ. You are not all, people are not the same. Reminds me of that episode, Monty Python, Life of Brian, the movie, how it ends with, people are worshiping this guy, this regular guy, Brian, as if he's the prophet. And they're standing there, the mass is standing, and he opens the window, and he wants him to go away, say, go away, you don't, I'm just a regular person. And they are all kind of, yelling in appreciation. And he says, you are all individuals, he tells them. We are all, so they echo, we are all individuals. You're all different. We are all different. And then this guy, bashful guy, stands in the corner and says, I'm not. So, the reasonable you, not the reasonable person, not the one part of the mass. Personalized consumer protections. One of the most kind of tough, powerful legal interventions that we have are mandatory rules in markets, things that people cannot contract out of. And consumer protection law is an area where you have that, where people are required to have some provisions in their contracts. So we'll talk about those. But again, the reason is that Some people cannot bargain for these things, do not know that they need them, but people differ. So instead of one-size-fits-all consumer protection, everybody gets the same disclosure, everybody gets the same right to withdraw, 72 hours right to withdraw from a mortgage or whatever it is. You can have different rules for different people. Personalized punishment. Well, punishment is already to some extent personalized, but it is not done with the power of machines. It's done through the cognition of courts and sentencing officers who have created for us one of the most disastrous, biased, and discriminatory systems in all of American law, because they look at the wrong things. So if some people are subject, let's say, to more policing, disproportionately more policed, they should be, according to optimal theory of punishment and deterrence, subject to lesser punishments. Personalized default rules. So Porat, my co-author, and Lior Strahilovich wrote a paper about personalized default rules. And here's a great example. Interstate allocation, so under inheritance law. How does an estate allocated when somebody dies? Well, in Illinois, 50% to the remaining spouse and 50% divided between the children. One size fits all. But Porat and Leo and Strahilovich said, look, people, when they write wills, they don't write a one-size-fits-all will. We know that men bequeath more to the remaining spouse than women do. So there is, gender matters. It depends on wealth. It depends on how many kids and which marriage it is, philanthropic propensities of people and so forth. We can tailor to each person a default interstate allocation and make it unnecessary to write wills, because we can predict what this person will do. Anyway, most people don't even know how they want to allocate. They go to a trust lawyer and they help them figure out how to do it. So there are factors that are taken into account. All of that could be, as you see, could be done. So these are all examples. And in a field where, if you look at the vast area of law that is called mandated disclosure, information that is given to us to help us make decisions. I'm taking just one example, food labels. But all product warnings, all investment warnings, all mortgage disclosures and so forth are all mandated disclosure. They are always given one size fits all. You buy a drug, you open the box, you unfold the insert, and they are the list of all the risks that everybody gets. Why? Different people care and need to know different things, which we can predict, again with the power of AI. So you get the food label, instead of all the information, just put your phone on it and it will give you your personalized nutrition data information. So that's the one part of personalized law. The other part is, as we said, derived from machine sorted information, and I've already mentioned. It doesn't have to be. Look, personalized law can be kind of a low-tech. Judges can have high, medium, and low level when they apply the negligence rule. But we're thinking more of a continuous range. So that algorithms sort through this, the big data and identify the factors that matter, and as I said, issue personalized commands and communicate them to people in manners that use their personal devices and so forth. And I'm working now on a study that looks how auto insurance companies collect information about how people drive from tracking devices that are either people have to agree to them. Opt in to have tracking devices in their cars. Many new cars are now connected cars, so the information is in. And you can see how people, how close they get to other cars. Sharp braking, hard cornering, excessive speed, and so forth. And do the charge premiums based on that. Surprisingly, there are states that don't like it and forbid this, notwithstanding the fact that these kind of methods reduce accidents and improve the way people drive, but that's a different story. That will be my CDI in lecture in 2 years. But the law can do the same thing. It can get this data of how people drive and figure out whether to allow them, or predict how people will drive, which is then the idea of machine learning. Not just tracking people, but then beginning to make predictions based on similarities between people and figure out how to create, the licensing rule that we discussed earlier. When should people have a driver's license? Does it have to always be the age of 16 or 17, the uniform rule? When should people begin to have a sunset of their driving? No longer can drive because they're too old, or should at least do some testing. Or pilots can no longer fly after a particular age, but why the same age? Some pilots at the age of 60 are at the prime of their spatial command and ability to fly a plane. They don't need the extra precautions or the sunset. All of this can be done through. Okay, so the upside of personalized law is, well, kind of so obvious that the book we wrote spent only one chapter on it. Personalized everything is better than uniform everything. That's how I think we think about so many areas. Well, not everything, but so many areas. Personalized shoes, better than one size fits all. Personalized diets. We now know that this entire industry, sham industry of diet recommendations, diet books that gives you one size fits all formula on how to eat better and be healthier, which, by the way, there's a lot of evidence that none of this really works long term. But the whole premise of it is misguided, that our bodies are the same. There's a fantastic book called The Personalized Diet about a model that was a machine learning model that predicts how your microbiome, how your digestive system will respond to different foods. And it's different for different people, with much more success. Some people add weight by drinking Diet Coke rather than Coke. It's striking. But that's how, that's the upside of personalized law, that it can advance the goals of the law with more precision. Any goals of any law, it's not about efficiency, it's not economics, it's not about, making America wealthier. If the goal is to serve weaker populations and to protect, it's protective goal, to protect people who need protection, identify the people that need protection, and don't just throw the net of protection to everyone, and then only the elites that know how to grab it will grab it. So there is more precision in the delivery of so-called legal services, namely legal rules. And enormous body of literature now and studies show the advances that have occurred in the past decade or two in medicine, education, marketing, many other areas in the shift to personalized treatments. And we now smart people in the past used to think about this, but can law be more personalized, less uniform? But dismissed it because they said there's no information. So Oliver Wendell Holmes said that the common law takes no account of the infinite ways in which people differ, temperaments, intellect, education, because it's impossible to measure a person's powers and limitations. Well, if that's the reason, it's no longer a good reason. So what are the downsides? And we'll talk about it. Is it fair? Is it constitutionally permissible? Doesn't it violate equal protection? Problems of coordination? How do you make, can every person in the marching band march to their own rhythm and beat? Need synchronization in society. And data in the hands of government. Scary things, important limiting principles that I want to get to. I'll just briefly mention how, how Porat and I were thinking about it. We started this by thinking about personalized negligence law. Can standards of the reasonable you idea and existing law is, of course, as we said, is uniform, uses the reasonable person standard with some very limited tailoring. For example, experts, specialized doctors have higher level, are required to take higher level of care than, kind of generalists. But very little of the pockets of this. And instead we will have a pool of one, the reasonable you, what you should take, and people who are known to be riskier should take more care. People who have more access, more cheaply can deploy precautionary methods should be required to take them. So the levels, the level of care, the standard of care, the standard of due care would vary according to this risk and skill factors. This would lead to more efficient care because, and would reduce the cost of accidents, one of the primary goals of tort law. Dangerous actors will take more care because they create higher harms. So it's important to motivate them to take care. And those who are skilled at taking care, who have access to precautions, should be required to take them and not just do what the average person do. You can think about it as a personalized net formula. But it's not only efficiency. Most people that think about tort law actually don't believe that the goal of tort law is deterrence and the reduction of the cost of accidents, but rather to achieve some conception of corrective justice. That there is a duty owed by a person who created risks to those, to their victims or potential victims, to remedy it or to make sure that it doesn't happen. And while I'm not sure that all corrective justice thinkers would agree with what I'm saying, Porat and I think that if you are a person who walks around and emits more risks to the people around you, you owe them a greater duty. And so I see this as personalized law as advancing a more appealing conception of corrective care, of corrective justice. I'm not sure about skill. The idea that your ability, that if you have at the tip of your fingers greater access to precautions, that you have to do this on grounds of corrective justice, possibly. I don't think corrective justice is necessarily, thinks in this term. This is more of a deterrence, economic way of thinking, but possible. There is an argument that when we started presenting this idea was raised against it, and that has to do with the problem of coordination. Imagine that different levels of care, different people have to take different levels of care. So think about a highway. And different cars have to drive at different speeds because different drivers create different risks. Some that see better, Mario Andretti can drive at night when it's raining faster than I can. Should be allowed to. He's a race car. But what about pedestrians? They're walking around, they want to cross the road, and instead of cars coming at uniform speed, now cars will be coming at different speeds. How will they be able to coordinate their behavior? This is the problem that law has to coordinate. So, in this particular context, I think I have a response, but the general concern is valid. The risks, drivers are driving at different risks. But if they were driving at uniform risk, they're driving at different speeds. But if they were driving at uniform speeds, they would be creating different risks. The almost blind driver would be creating a greater risk than the very good proficient driver. So what personalized law is trying to do is to make more uniform, not the commands that people follow, the duties that they have, but the risks that they create, which should make it easier for pedestrians to know what to do. Cars that are coming fast, those are the safer drivers. I'll skip this. I want to get to one more example, personalized consumer protections. So examples for consumer protections are right to withdraw. Maybe the most important right is if you're not happy, you can get your money back. Many vendors give it, but it's not mandated in American law. It's a mandate in many other countries, in Europe, for many transactions. Privacy protections. Again, not a lot is mandated, but the claim in the privacy circles is that there should be limits on what firms can do with our personal data. Mandatory warranties, lemon laws. When people buy cars and the car is a lemon, they can get a replacement. They don't have to bargain for that, they get it. It's a mandatory rule. You cannot forego it. Statutory damages for various violations. But mandatory protections are needed because people are not bargaining for them. And people are not bargaining for them because they are less sophisticated than the sellers that sell them goods. And some people are less sophisticated in an important and meaningful way, and some people are not. Some people are not. I'm not sure that I need, as a buyer, mandatory protections. Whereas I think that the notion of a consumer being weak relative to the vendor has to do with experience, education, sophistication, knowledge, how much insurance they have. All of these factors, people vary on. So why not give more protections to those who are really weak and not others? Why not target that protection in a personalized way? And that will overall create greater surplus, especially to weaker populations. The right distributive conceptions give the protection to those who need it, and solve a problem that I want to say one more thing about it shortly, that when you give it uniformly, who enjoys the consumer protection most? That's mountains of empirical data show that those who need the least. So much for our uniformity under the uniform law. So the objections. The first objection is kind of a philosophical objection. Isn't law that almost by definition have to be equal? Aren't we all equal under the law? Distributive, this is the list of things, and I want to go over it. So is it just to give people, is it fair to give people non-uniform rights and duties? Shouldn't the law treat people alike? If you go to any courthouse around the world, you're likely to see someplace the statute of justitia, the goddess of what? The goddess of God, justice, yes. And she is blindfolded. She doesn't see people, therefore doesn't change the treatment of one person to the other. This is I think, a very kind of powerful representation of the notion of uniformity. Everybody is the same when they walk into the halls of justice, to avoid preferential treatment to the elites, to the powerful. So the problem is that it's just just an aspiration, justitia. People are not really treated the same. The uniform allocations often end up, in the first place, they are unjust because they don't take into account important differences between people that need to be taken into account. I love this phrase this statement by Anatole France, and every time I kind of think about it every day when almost everything I see fits this idea. That the law, he says sardonically or ironically, in its majestic equality, forbids the rich as well as the poor to sleep under bridges, beg in the streets, or steal bread. Uniform laws have non-uniform impact. What is guaranteed to you under the law, de jure, is not what you get de facto when you need the sophistication and the representation and the resources to insist on your rights. Not to mention that it gives a lot of discretion. Uniform law gives a lot of discretion to lawmakers, enforcers, judges, how to exactly apply it in specific cases, resulting, as you know, in unequal application. I guess my main point is that equality does not depend on how many factors we take into account, but how relevant they are. There isn't, all laws make some distinctions. So for example, the alcohol age rule, age 21, differentiates people that are under versus over 21. But we say that's not discrimination because everybody is subject to the same formula. Everybody has a chance to satisfy it when they get to 21. Now you can throw in an additional factor that seems relevant. If you're up to the age of 21, and let's say no prior record of reckless behavior or abusive behavior. That is also fair in the sense that the formula applies the same to everyone. All personalized law does is it puts this method on steroids. More and more and more factors that are all proven to be relevant. But the formula is still the same for all. And this is a concept that I think we talk a lot about when I teach insurance law, of actuarial fairness. Is it okay to charge different people different premiums based on the weight they put on the insurance pool, how much risk they bring in? Almost every state Supreme Court, and many of them have addressed this question, and said not only is it okay, it is required under notions of justice to treat people differently based on a uniform formula that says you have to pay the basis of the risk you create. I'll skip this. Let's talk about for a moment about equal protection. With personalized law, use suspect classifications: gender, sex, race, religion, ethnic origin, age, things, protected classes. Well, maybe to some extent. To a small marginal effect among the 100 factors that determine what is your standard of care that you take, it might take into account the fact that you are, your biological sex or your gender. Not strictly, not put all men and all women in two different bins, but you use that as one of the factors. There are studies that show that people's preferences for organ donations, that's a default rule, whether you are enrolled, differ in part based on race. So why not give them why not take that also into account? Again, it's not one rule for people of particular race and all people of particular race and another rule for people of a different race. But that is one of the factors that gets 2% in the weight of the algorithm. I'm just giving, just spitballing here. And so on and so forth. These are examples of how things could work out in personalized law. Of course, you can rule these things out, but of course, algorithms will figure out surrogates for these factors. Does the principle of different rules for different people violate the 14th Amendment guarantee of equal protection? So I don't think so. And I spent the whole chapter in the book with Porat, and I spent the whole chapter trying to go through the case law and see what the courts at least used to demand under equal protection. What people have to be treated individually. And part of identifying them as individuals is also the characteristics that are thought to be protected or are protected or suspect or classification. But you can't treat everyone simply according to these rules, based only on the membership of in the class. It's prohibited to pull all members of a group into a separate treatment. At the Gruder v. Bollinger case that is, hanging on a thread right now, affirmative action in higher education, the court said that at the heart of the guarantee for equal protection is the government must treat citizens as individuals. It should be flexible enough, the formula, to consider all pertinent elements, including race, and to place them in the same footing for consideration, although not necessarily according them the same weight. That's exactly personalization. So that kind of tries to answer, I'm not a constitutional lawyer, but I think that this at least creates some kind of, it's a good candidate for a rule that would satisfy equal protection and would provide treatment that does take into account the fact that people have characteristics that are otherwise protected. So I see personalized law not as a problem for equal protection, but as a solution. That I think that even today's Supreme Court would not oppose to the affirmative to school admissions policy that is personalized, even if it takes into account as one of the factors protected suspect classifications. There is, I want to wind up to the round up and conclude very shortly. One criticism against this entire enterprise, and when I say stand in a cocktail party with people now, that have thought about this, or with students when I told, chatted with students in the entering student kind of dinner or receptions at the end of the summer, asking what I work on. I told them, hey, they said, well, but once you have to train algorithms based on data to identify people and to make predictions about people, the problem is the data. The data that algorithms will get is full of information that reflects past injustice and discrimination and bias, and it would only perpetuate that. If a data, this is very much in the core of the debate over using algorithms to predict, to do risk assessments in bail, parole, and sentencing in criminal law. The data might show that members of racial communities or different people in particular low-income neighborhoods are more likely to be risky. But why? Because they are arrested more often. Why? Because police presence is more intense in their neighborhoods. So that shows that or because there were some other practices in the criminal justice process disproportionately document some groups' propensity to engage in risky behavior or in criminal behavior. It does not necessarily reflect true differences, and that's the concern. Well, this is a concern that afflicts our system even without AI. Judges applying uniform law and police and prosecutors applying uniform law are also prone to, and there's also a lot of statistical evidence showing prone to these biases to perpetuate them. And so much effort is spent in several circles on thinking about reform. How far have we gone? Maybe you need to give a chance to a different scheme that is at least transparent. In the algorithm, you see what the factors are that are used. You're not happy with the fact that the algorithm takes into account a particular factor because you think, for example, past arrests or something like that, because you think this factor is not clean, is biased. Cross it out. It's just a line of code. Try to make changes like this with judges. So it's easy to see and easy to fix statistically these things. It actually is there are much more powerful statistical tools to eliminate even disparate impact. Even if the algorithm's tendency to find factors, not allowing the algorithm to see the race, well, they'll figure out, they're smart, they'll figure out how the person's race based on zip code and other things. Well, there are ways statistically to solve even that kind of proxy impact that creates this proxy effect that creates disparate impact on groups. I don't have time to go into this, but very exciting ways that to do corrections for past injustice that we don't have with our present scheme. So this is the gist of the project, and in a little time that we have, sorry I spoke for so long, the little time we have left, let's talk about it. Yeah.
I have a question about the data collection, and so look, my impression is that for a lot of these machine learning models in particular, the amount of data you need to have very good, robust predictions that we feel are accurate and not being skewed by something is immense, like really, really large. And this is one of the reasons people give why ML so far has not had like a huge impact on productivity growth, for example. Now, when you give an example, to take two of your examples, one of them is like people driving in cars with trackers on them. Another is I want to drink and I'm underage, right, by the current standard. In the former case, I can understand how we have like a lot of data on how somebody drives, because you're literally measuring the thing you care about. In the latter case, I have no idea how we'd go about measuring my risk aptitude when I drink or not at different ages, right? Like, maybe you would say the things that we can measure are general proxies for risk, and that translates across contexts. But how could you know that without measuring the other thing? So sort of the question I'm asking is like, given the disparities in data collection across contexts, how universalizable do you think this is, or do you not think that that's a problem?
Well, a great question, and I think that this is maybe the primary implementation limit or limiting principle on that. Even if you normatively buy in, and there are so many other problems on the normative side, there is just this operational problem. Do we have enough data to do it really accurately? And you know, I have a chapter in the book that thinks soberly about this, very much motivated by the spirit of your question, that we might need a lot of more data than governments can have. Where will they get that? From insurance companies for that purpose? Well, that would solve the problem, but insurance companies say it's proprietary. From Facebook, based on pictures, people showing themselves drinking, you know, like binging and stuff like this. That will also be probably good predictors, but Facebook doesn't want to give, it's complicated. So all I want to say is we are gradually shifting into a world in which more and more data will come. So I'm thinking about applying this, offering this as an experimental legal paradigm. Once we cross in areas of law where we cross the point that we have enough data, that we feel confident enough that the algorithm's trained will make good enough predictions for the purpose of advancing these laws. You know, I read this book, Personalized Diet, and I looked at the data that is used by the model, the machine learning model, to predict how different people's bodies will respond. What's mind-boggling is that they only needed a sample of a few thousand people to figure out the different types of responses, and relatively little amount of information from people who wanted to join the model to make predictions for them. So how massive is the data depends on context. Yes, in the back.
So the last criticism you addressed was the use of algorithms may perpetuate historical bias or prejudice. But you said to counteract that, we can look at the algorithms and we'll know what variables we're considering. We could alter them if we find that certain variables are completely biased and not achieving the goal we want. But like in the context of risk assessment for bail determinations, that information is proprietary. And so defendants cannot ask and investigate what is in the algorithm that's determining whether they get bail or not. Do you think that that's a problem if we make personalized law thing and on a bigger scale, if that information is proprietary? Like, does it need to be public algorithms?
Yes, it's a scandal that these algorithms are proprietary. It's atrocious. You take a good model and turn it on its head and make it entirely unacceptable. That people are subjected to risk assessment based on scores that are given by proprietary models, and they are not even allowed to scrutinize what the factors are. Even judges are better than that. You know, they might be more biased, but at least they're trying to give you reasons. Wisconsin is a state that permitted this proprietary model, and I hope that this kind of approach would not last. First of all, it's a bad model. It's a private company called Compass that created the model. We don't even know what, but based on some studies that have been done by academics, it's not a good model. There is no reason why any state should use it, because the model developed here at the University of Chicago by Sendel Mulenathan and co-authors is available free, and it's some localities are using it. So there's no reason to take away from the algorithm or the model, from this paradigm, one of its great legitimizing factors, the fact that it is publicly available, transparent, watchdogs can check it, can look at it, and the fact that, as I said, it can be fixed when you see a problem. So yeah, I share the sentiment of this question. Please.
Is there a way in the world of personalized law for you to sort of challenge the law? Because, you know, if we're talking about drinking age, for example, if I'm under 21 and I don't like the law, like that's too bad. But I could theoretically like lobby Congress to change the drinking age, and I could get a bunch of people on board who feel the same way. But if it's all personalized law, we have the same situation where the law applies to me and I can't change it just by myself. But also, if everyone has a different law, how do I say to Congress, oh, like the law is wrong,
right?
Because there's no real way to change the law if it affects everyone.
So I'll say two things about this. It's a great question. First, the factors that determine what your personalized age or capacity is would be transparent, so you can, teach to the test. Try to score well on these things. It's not a great thing that people will manipulate only the factors that the algorithm chooses, but at least these factors are correlated with the risks that we're trying to do, so maybe it's not that bad. About changing the law. This touches on an issue that is was very hard for Ariel and I to resolve. Because look, nowadays when laws are made, they have goals, but you don't really have to specify the goal that accurately. There is a particular safety rule under the EPA or Department of Transportation. We know that they want to do all sorts of things, increase safety, but not increase too much cost, maybe take into account the environment, and maybe they throw into the statement, or the lawmaking statement, all the goals. But that's not going to be good enough for personalized law, because in order to build an algorithm that creates personalized rules, we need to know what weight would be given to each goal. Law has never worked this way. Lawmakers are allowed to fudge. Lawmakers are allowed to say one thing, but actually have a deal with interest groups to write the rules a little different. The whole idea of interest group lawmaking that allows to allow some objectives to enter in a stealth manner into the law will not work anymore. If the pharmaceutical industry wants a particular rule written, it'll have to be out in the open, because they will see what weight it is given in the overall instruction that the algorithm gets when they are when the instructions are given to regulators to develop this algorithm. Maximize the following three factors, 1/3 each: environment, safety on the roads, and the interest of Detroit car makers. So I see this aspect not as a bug of personalized law, but as a good feature. That in lawmaking, we will have to be very clear about the goals. Maybe a couple more questions. We have time. Yes.
Thank you so much for your lecture. Going on the same road analogy, I'm curious about the factors that you choose. So some jurisdictions, like Finland comes to mind, their fines are means tested. Do you view means as an internal factor or as an external factor? And the follow-up is, what do you think about how it would be subject to constitutional scrutiny in the American context?
So I view means as an example of personalized criminal sanctions. Finland, as the question raised, it told us, uses what they call day fines. The unit currency that is used to determine what is the fine for a particular offense, let's say crossing a red stop sign or parking in an illegal spot, is not stated in the the going currency. What is it in Finland?
Krona?
Krona. It's not in krona, but in fractions of your daily income. Now, in Finland, everybody makes, they all make the same income roughly. But there are some people a little bit high and a little low. So for this particular, for speeding, it's 0.65%, 65% of your day income. That's the day fine. That's the fine. And so different people, they pay different amounts based on one personal factor, which is income. I love that. There's really no reason why we should all pay the same fine if the idea is to place a burden on us so that we would avoid doing this. We don't think of fines as prices. Oh, you're just buying the right to park at a handicapped spot, because it's more convenient for you. So if you're wealthy, you'll do it all the time. Oh, you shouldn't do that. And so why not? If you believe in if you have this vision of fines and sanctions generally, not as prices, then why not graduate them based on the burden that they create? And if you find other factors that matter, or they think are more important, they also should go into the personalized fine. That's an example of a very nice method of personalizing the fine. Yes?
So you were talking about the concern of this kind of data in the hands of government, but then also you obviously contemplate the data going up a bit outside government, like if people need to comply with different standards of care. And I wonder, going even further, do you see an extent to which individuals should have access to other individuals' factors for data? Like if I'm, again, to go back to the road, if I'm on Lakeshore and I'm driving and there's somebody who has an incredibly high risk score, like maybe I just want to pull up, or I want to slow down a lot. But then you can see how, and we choose to do this sometimes with, like a sex offender registry or something, just as a rough example. Is there a limiting principle there?
I didn't quite think about that question before. It's a very interesting one. My intuition says yes, there should be, but only to the extent that it really matters for privacy, not for some kind of normative conception of privacy, but more for what people really care about. I don't mind if I drive in my connected car on Lakeshore Drive, and other connected cars will know what's my safety score. My car gives me, by the way, a safety score. I'm enrolled in its insurance program with the automaker. They give me a safety score, and if others know, hey, here comes a car that is, they'll see on their dashboard, like some of the cars have, they can see the road, they can see other cars. So some are red, some are green, some are purple, some are, black, depending on their safety score. That's fine. It's nothing that violates my privacy sensibilities here. But if someone can log in my imagined, let's say, inheritance.gov website, and instead does not need my social security number, but can just check through my name, what is my interstate allocation? How will my allocation be divided? Or what is my organ donation default? Maybe that's not something I want people to necessarily be able to do. So in the context of age of capacity, people have responded to this example by saying that folks will be publicly shamed, not allowed to buy alcohol, not allowed to drive. So these things, to reduce shaming, these things should not be, people will find out, but they should not be kind of announced in a free and open way, so as to protect meaningful conceptions, meaningful sentiments of privacy in society. I would see it that way. Yes, in the back.
I think you spoke about the admissions process, and I was wondering for Harvard and UNC, if they switch to a personalized algorithm-driven process, how does that actually incentivize high school students to be better students, or in whatever Harvard and UNC wants, put more effort into sports or something? How would the students know how to respond to those personalized incentives?
So it's a good question. There are some areas of personalized law where if you acquire more skill, more education, more sophistication, more knowledge, more competence, more capabilities, you will receive less favorable legal treatment because you don't need big protection. You don't need consumer protection. You don't need the, mandatory layman laws. You will get less. So maybe people will try less on the margin. I doubt that. There's so many benefits to acquiring competence and capabilities that I think way overwhelm these remote kind of contingent lost privileges that we gave the law. But also in other areas of the law, it might give you a thing about these personal characteristics. It might affect you one way in some areas of the law, might affect you differently in another area of the law. Insurance companies ask people about their education, especially young youth drivers, and if they have good grades, that reduces the youth driver premium. That's not something remote, that's an immediate $150 discount every year. Just making up the number, but that's kind of the ballpark. So I don't know that there will be, in the end, I think that people acquire education because they are kind of driven to know. Right? Not because they're thinking, if I will, then when I buy a 55-inch smart TV screen, I might get a bigger or lesser mandatory warning. I don't think about it this way. Yeah.
I'm curious if you have any thoughts about what issues might arise with sort of notice and the ability for a person who is affected by a personalized law to understand what their burden is. So the negligence example kind of weighs heavily to me. Those risk factors that any individual might have are perhaps shifting dynamically. How will they know at any given moment what their level of care might be to the people around them, and does that present problems?
Yeah, it presents problem, and a lot of the things would require some kind of connected technology to give people information. The book begins in the introduction of the first chapter, the introduction, with a 3 or 4 page kind of parable of a couple's life in the futuristic world of personalized law, how they get the information and how things differ for them, and they a lot of it goes through connected devices. They check what they're they have to, for example, in order to start a car, they have to breathe. In some situation, they have to breathe into built-in little blood alcohol measurement device, because the car will know that they just came out from a restaurant and part of the bill was a bottle of wine. But different, different people would have different thresholds based on their BMI index, based on other things that make them more tolerant to alcohol. So how these things will occur in this, it requires some technology, but at the rate in which everything that we have is connected, and the size of the little measuring, tracking, surveillance devices that are needed in order to collect as it becomes smaller and smaller, I don't see that as necessarily a big limiting principle. To the extent that it is, if you cannot communicate some things, then the personalized commands will have to be cruder. I think you've all earned your lunchbox, so I'm going to stop at this point and thank you for listening.